The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebrite, and today we're talking with Holly Cole, Director of the Equal Employment Opportunity Commission in Oklahoma, and my GableGotwals partner, Ellen Adams, about Bostock versus Clayton County, which was a landmark LGBTQ plus case decided by the United States Supreme Court in 2020. So now, Holly, before Bostock, how did the EEOC approach charges alleging discrimination on the basis of sexual orientation or gender identity?
Thanks, Talitha, for asking me to speak today. It's pretty exciting because actually we're right at the 3-year anniversary mark of the Supreme Court's decision. It was decided on June the 15th of 2020. So we are about, 6 days after that. And as we sit here today in June, we're also celebrating Pride Month. So it's a very timely topic and an interesting one to talk about that continues to evolve. But yeah, to answer your question, the EEOC has, even prior to Bostock, has been on the forefront of promoting equal rights for the LGBTQ plus community. So something that some folks may not realize is that the EEOC is the appellate body for charges of discrimination filed by federal employees. So the Office of Federal Operations has the ability to issue opinions, which are basically court opinions that are applicable in the federal sector. So in 2012, the called OFO, but the EEOC issued an opinion saying that a decision to hire an applicant based on gender identity violated Title VII of the Civil Rights Act, that it in fact was sex discrimination. Then later on in 2015, the EEOC also decided that discrimination against a person who was seeking permanent employment with an agency, and that decision was, the decision not to hire that person was based on their sexual orientation, that also was sex discrimination as it's defined under Title VII. So the since the passage of Bostock, the EEOC has issued some guidance which is very comprehensive and continues to track the evolution and the opinions that are coming from the various courts as a result of that Supreme Court decision. And that can be found at eeoc.gov for more reading.
Wonderful. Thanks, Holly. So now, Ellen, from my understanding, the Supreme Court in this case wasn't considering just one dispute, right? They were looking at 3 different sets of facts and taking those into account when rendering its decision. Can you tell us a little bit about those 3 different sets of facts?
Sure. So 2 of them involved claims that someone had been discharged based on their sexual orientation. And one of those claims, the allegation was that they'd been discharged on account of their revealing to their employer their intention to appear at work as a female when they had historically appeared at work as a man. And so those cases were kind of taken together, and without getting into the details of the particular situations, which are kind of interesting. One was a skydiver, one was a funeral director. So not to say there aren't interesting facts there, but to avoid getting mired down in them, really the Supreme Court was looking at the issue of the language of Title VII, which the language of Title VII has discrimination is illegal or unlawful on account of, because of sex. And so historically, there was a circuit split about what exactly because of sex meant. And these cases eventually ended up before the Supreme Court to resolve the issue of whether because of sex in the discriminatory context meant because of sexual orientation or because of gender identity and sex stereotyping. And in a 6-3 decision, they landed on interpreting because of sex as inclusive of sexual orientation and gender identity, including transgender status. So I hope that answers the question.
Well, it does. And I think, so would you agree then that in a nutshell, what it basically means is that employers cannot discriminate against employees or prospective employees on the basis of their sexual orientation or their gender identity?
Absolutely.
Is that an accurate sort of nutshell of the decision? Great. Wonderful. Yeah. Well, today, this is a bite-sized episode today. We just sort of wanted to introduce the topic of the Bostock decision, which had, a pretty profound impact on this area of law. And so thank you to both of you for explaining that to us. I think it was really particularly interesting to me to hear how this, 2020 case followed what the EEOC had previously decided in another context with respect to both sexual orientation and gender identity. So that was really interesting information for me to hear. So thank you to Ellen and thank you to Holly. We appreciate it. And thanks to you for listening to the Employment Roundtable. Please join us next time as we dig a little deeper into Bostock and discuss how it has impacted employers' obligations in relation to their LGBTQ+ employees. The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.